Welcome to Rapid Fire Wednesday, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in San Diego, and I'm joined today, as always, by Miki Matrician, our co-managing partner of the Boston office. Hey to you, Miki.
Hi, Kim.
So the CAP H-1B registration window has officially closed for this fiscal year, and USCIS is going to run its randomized computer-generated lottery by March 31st. So employers for selected foreign nationals will file the H-1B petitions from April 1st through June 30th. And then at the end of that period, USCIS is going to review how many cases were received to see if the quota was met. And if it hasn't been met, they will run another lottery drawing based strictly on the March registrations. So we're getting geared up for that. And today we would like to discuss alternative options for those individuals who are not going to be selected in the H-1B cap lottery. And for those who are on F1 OPT, that will be valid until after April 1st of 2026, which is next year. They can continue to work on their OPT. But there are some other considerations for individuals. So, Nikki, what are some of the other possibilities that human resources and global mobility professionals can consider for their employees that might not be so lucky to have work authorization through next April 1st?
Yeah, so if the employee is married to an H-1B visa holder who also has an approved I-140 immigrant visa petition, then they can file for an H-4 employment authorization document. If they are married to somebody in L1 or E visa status, based on the current rules, they can work without having to file any application for their employment authorization document. They just need to have an I-94 that says L2S or E1S or E2S.
So that seems pretty simple for those individuals. But what about people who might not qualify under that alternative? Is there something that they could possibly leverage with cap exempt organizations?
Yeah, sometimes it's a possibility, to work part time for a cap exempt organization in addition to their private employer. So, concurrent employment. So, what do I mean by that? Certain types of employers are not subject to the H-1B cap. For example, universities and colleges, nonprofit organizations that are affiliated with universities and colleges, nonprofit research organizations, and government research organizations. So, those types of employers can file H-1Bs for their employees without having to go through the lottery. And so, if a foreign national works for a cap exempt employer and simultaneously a private employer, that private employer can file an H-1 petition without going through the H-1B lottery. But if they decide to stop working for that cap exempt institution, then that individual would need to have an H-1B selected in the lottery and counted against the cap.
That's some good options. And then for some types of employers, they may have affiliations with universities such as biotech companies, which is, pretty big here in San Diego, as well as where you are, Mickey, in Boston. So in those instances, they might have a good strategy in which the lottery may not apply, right? If they're able to get in under the cap exempt criteria. But, not everyone is going to be so lucky. So, Mickey, can you talk with us about people from countries that might have an alternative if they are citizens of countries that have free trade agreements with the US and what their alternative options might be to stay and work in the United States?
Yeah, so for people who are citizens of Chile, Singapore, and Australia, they have alternative options under the H-1B1 visa or E3 visas based on those bilateral agreements with the US. And so, just like the H-1B, those visas are for specialty occupations, meaning that the position must require a bachelor's degree in closely related fields of study. And also, like the H-1B, there are wage obligations on the part of the employer, as well as other compliance requirements like providing notice to employees and maintaining compliance files. And then for Canadians and Mexican nationals, certain occupations may be eligible for the TN visa under the USMCA treaty, formerly the NAFTA. So the role has to be one of 63 occupational categories that are listed on the appendix to the USMCA.
Okay, so those are some good options. And then I guess as we continue through the alphabet of immigration, what about the treaty trader and treaty investor visas as alternatives to the H-1B classification?
Yeah, so the US State Department has a list of countries with whom there are treaties of commerce and navigation. So if your publicly traded company is headquartered abroad and is listed on a foreign stock exchange, and the employee is a national of the same country, the E1 Tree Trader or E2 Investor visa might be an option. Let's say if the company is not publicly traded, if the company is at least 50% owned by owners with the same nationality of the employee, an e visa may be possible. And with that threshold requirement, the foreign national has to be an executive, supervisory, or essential skills worker.
So, again, some decent options for a lot of other individuals. And then there's also the O1 visa classification, right, which is for an individual extraordinary ability. So a lot of people think that they are eligible for this classification, but it really has a very high bar. So having a PhD, which is an amazing accomplishment, unfortunately, it does not automatically make someone qualify for the O1. It specifically has to be that the individual is accomplished and known for their contributions in their field, which is in the sciences, art, business, education, athletics, or motion picture and television. The individuals also have to be at the top of their field and are recognized nationally or internationally for the work that they've done in their field, either through receipt of an international or national prize or through documentation showing that they meet 3 of 8 very specific criteria that are spelled out by the Immigration Service.
Yeah, I totally agree. This is not an option for people who are early in their careers. It really does require them to show their record of achievement. It's potentially a visa option for someone to work towards with a strategy to engage in activities that will meet the required criteria.
Yeah, that is definitely something that people can put together, right, to have some possibility in the future. So sometimes, companies look at other alternatives, and that might be if a company wants to bring a foreign national to the United States to be trained, and the company has a specific training program with a classroom component and a curriculum, then an H3 visa classification could be a possibility. And you did hear me correctly, there is a classroom component, so that's one thing that trips up a lot of employers, and it has to be, definitely part of this H3 option. So, the reason, that there's a classroom component is something that is in the regulations by USCIS because it is for training and not strictly, completely hands-on training. So, the H3 option, unfortunately, is highly scrutinized by USCIS. So, something to consider, just making sure that the company has all the pieces in place for that category. And then another training classification that's an option is the J1 exchange visitor. And this is a possibility for individuals to come and obtain training in the United States. So the J1 for a trainee requires that the foreign national have a foreign degree plus 1 year of related work experience outside the United States or 5 years of related experience in the US. So if the foreign national employee is doing research, the research scholar could be the worth looking at for J1 classification. And one thing to really, really think about before proceeding down this path is that the J1 exchange visitor classification does have a foreign residency requirement that is composed with it. And that's only for specific individuals from specific countries based on either funding that they've received or skill sets that they've received. So that is something to look into to make sure that the person isn't going to be here in the J1 for a short period of time, then has to stay abroad for 2 years. So those are some options that are alternative to the H-1B classification. So HR and global mobility professionals and employees can, talk about and look through whether or not these alternatives are available for the foreign national employees if they are not selected in the H-1B cap and don't have particular work authorization that will get them through to next year's H-1B cap in 2026. So that's a wrap for today's rapid fire session. Stay tuned for future episodes on updates to the immigration landscape. If you don't already, please follow us on our LinkedIn page for WR Immigration as well as our individual profiles. And we also transcribe each and every episode and post it to a weekly newsletter that you can subscribe to. And the link to subscribe will be in the video description. So until next week, have a good one, Miki.
Thanks, Kim.